Here it is pertinent to mention that the case study where the witness protection was provided, the Narada Patia case, as it is a carnage in 2002, where the key witness Muhammad Shakur Said was apprehending his life. He is the key witness and his life was in risk, therefore he sought the protection from the honorable court, but it is a matter of regret that only one guard was provided to him to protect his life, but the guard rather protecting the life of the key witness, he apprehended his life, and accordingly the witness was not feeling any free to depose the evidence before the honorable court, and as his life was in peril, therefore it was not sufficient protection given in this particular case. Even the Ketan Thiradkar case, the ex-journalist whose life was in risk, and the witness, as a key witness, he sought the permission or the protection from the honorable court to get the protection. Even in the twin blast case, section 30 of the Prevention of Terrorism Act, it was clearly revealed that the protection should be provided, but it was not sufficient at all. The Whistleblowers Protection Act of 2011. There in this particular act, the mechanism to receive complaints on disclosure on any allegation of corruption or willful misuse of power or willful misuse of discretion against any public servant. The section also says to provide adequate safeguards against victimization of the person making such complaint, and protection against victimization by initiation of any proceedings, application of witness for protection, and concealment of identity of the complainant. If we will go through the Law Commission reports, the 14th Law Commission report of 1958 gave importance on the witness protection, and in its recommendation it said that proper arrangement being provided in the court and the scales of travelling allowance and daily allowance in a limited sense, and the travelling allowance and daily allowance are not given properly, and the persons who are entitled to get the allowance are not getting it, and this is not sufficient at all. Then the National Police Commission report 1980, here also it is highlighted that inadequacy of daily allowance for the witnesses. The witnesses are not getting daily allowance, though the allowance has been prescribed under the code, still it is not adequate at all. The 54th report of Law Commission of 1996, here the protection and facilities to witnesses in the court has been given importance, and it is stated that the facilities, that is drinking water facilities, sitting facilities, medical aid facilities and travelling allowance should be provided so that they can depose, they can adduce the evidence freely in an honorable court, so that the conviction rate will be high, and it will support and the people will repose the confidence on the criminal justice system in India. At the same time, 178th report of Law Commission of India, report 2001. Here in this particular report, the committee suggested insertion of section 164 capital A in the CRPC to provide for immediate recording of the statement of material witness in heinous cases in the presence of a magistrate on oath, where the witnesses are reported to be under threat and coercion by the adverse party. Still, witness protection has never been a priority with the legislators. At the same time, Justice V.S. Mallinath Committee report on reforms of criminal justice system. Here the committee recommended the travelling allowance and other allowance should be fixed by the court, which is to be paid to the witness to compensate him for the expenses which he has spent, and proper procedures are to be adopted for the payment of such allowances. The committee also recommended the payment should also be given to the witness in case of any adjournment of the case and without examining the witness. And the other Law Commission report, that is the Law Commission of India 198th report 2006, it gave emphasis on the witness identity protection and witness protection programs. So in this particular report, the committee recommended that there is necessity for legislation on witness protection. It is high time for a comprehensive legislation on witness protection specifically. The committee also said that in different cases, NHRC versus State of Gujarat 2003, PUCL versus Union of India 2003, Jahira versus State of Gujarat 2004, Sakshi versus Union of India 2004, Jahira versus Gujarat 2006. In all these cases, the Supreme Court has emphatically stated that it is high time for a comprehensive legislation on witness protection. The 198th Law Commission report recommendation clearly says that witness says, and it has also defined the meaning of the witness protection. Here the committee in its recommendation said that witness protection programs refer witness protection outside the court. At the instance of the public prosecutor, the witness can be given a new identity by a magistrate after conducting an ex parte inquiry in his chambers. In case of likelihood of danger of his life, he is given a different identity and may, if need be, even relocated in a different place along with his dependents till the trial of the case against the accused is completed. If we will go through the international perspective, where the witness protection program has been initiated, where we will find the law on witness protection, especially the United States of America, where the Witness Protection Act 1970 has been enacted. In that particular act, there is a program, Witness Security Program, WITSEC, and it is the duty of the US Marshal Service to provide the witness protection that includes new identities and financial and employment aid to the witness. Even the Witness Security Reform Act of 1984 clearly says with regard to the witness protection to the witness, and it is a very comprehensive law which is prevailing in USA. At the same time, in Australia, Witness Protection Act of 1991 has been enacted. There the definition of witness has been defined, and the witness are defined as the person who is giving the evidence before the court, and even whose name has been registered in the birth and deaths and marriages register of 1959, that the name of the persons will not be disclosed. As per section 24 of this particular act, Witness Protection Act of 1991 in Australia, the victim and witness protection units has been constituted, and accordingly the protection has been provided to the witness. So if I will summarize all these things, let us summarize that after going through all these provisions and recommendation of law commissions, provision under CRPC, provisions under the IPC and the Indian Evidence Act, there is no general law on protection of identity of witness in criminal cases in India. Provisions for protection of witness in the special statutes governing terrorist crimes such as the Prevention of Terrorism Act 2002. And in recent times, the cases where witnesses are turning hostile at a trial due to the threats is no longer confined to the cases of terrorism. Even in other types of offences falling under the Indian Penal Code or other special statute, this phenomenon has reached alarming proportion. There is need, as in other countries, to generally empower the court in such cases where muscle power, political power, money power or other methods employed against witnesses and victims for the purpose of protecting the witnesses, so that witnesses could give evidence without any fear of reprisals and witnesses do not turn hostile on account of threats by the accused. Enactment of comprehensive law for witness protection in India is the crying need of the hour. Thank you.